Next on the docket, Phil Mickelson. He has to pay the SEC nearly $1 million that he made on an insider tip. Now, Mickelson made that much more profit in one day when the stock in Dean Foods that he bought skyrocketed. He allegedly received the tip to buy it from a pro gambler who got inside information from the former head of Dean. Now, the SEC says Mickelson then took the profit and repaid the gambler the money that he owed him. But Mickelson was not formally charged with a thing. Now, in a Times op-ed piece many of you may have seen, Columbia Law School professor John Coffey explains how Mickelson got off the hook while the others got indicted. Quote, "Neither the U.S. attorney nor the SEC is prosecuting other people who benefited from the stock tips, including Mr. Mickelson. Why not? A serious shortfall in our law has hampered prosecutors and allowed insider traders, particularly those further down the chain of information, to dance around the rules." Well, let's bring in Professor Coffey, who's kind enough to join us out of Manhattan right now. And Professor, thanks for a few minutes.
My pleasure.
You know, when I first read the story, before I saw your op-ed, I had to read it twice. I'm going to oversimplify this and tell me where, if all, I get it wrong. In effect, if a guy tips somebody else to inside information, even if the person knows he's getting inside information, which all of us thought was illegal when you're playing the market, he won't be prosecuted unless he knows for the fact that the tipper is also profiting from the deal. It can't be that perverse and that basic, can it?
You stated it substantially accurately. What the Supreme Court said a little vaguely in the Dirks case 20 years ago, and what the Second Circuit said a year and a half ago in the Newman case, is that in order to protect securities analysts and other people who perform a socially useful service, we have to have an absolutely clear, bright line. And that bright line requires that you know that the person giving you this information was doing it effectively in return for a bribe or some other personal benefit. And that's a very high standard. It allows the government pretty much to reach the initial tippee, as they did in this case, but not to reach the remote tippee 1, 2, 3, or 4 steps out on a chain of information. And that, in the world of Wall Street, means that there's immunity for those who trade in a favor bank but don't directly know all the details about the original tip.
You know, no good deed goes unpunished, I guess. The Dirks case you reference, it seems on the surface reading of it, Dirks was a good guy. He saw what was going on. Basically, if I remember right, an insurance company that was all but insolvent. He tried to go to the authorities. He tried to go to the journalists. He tried to go to everybody to say, guys, this is a charade here. There's no money behind it. Finally, he went to investors, let them know as well. They cashed out. SEC gets embarrassed. They'll go after Dirks. Supreme Court says, time out, you got the wrong guy here. He did the right thing. But in an effort to basically carve out an exception for him, they created what you wrote in the editorial was a standard that's kind of like don't ask, don't tell. As long as you don't know who's tipping you off is making any money or not off of it, you can do what you said in the Newman case too. Hedge fund guys make $72 million overnight, and they get the skate on it just because they didn't know the tipper was also making some money. It just defies logic.
Well, that is the predicament we're in. Mr. Bahara, the U.S. Attorney in New York, won some 80 or so convictions and guilty pleas for insider trading over his brief term in office. And since Newman, there are some 14 cases where he's had to let those people escape conviction, withdraw their guilty plea, get out of prison even, because he couldn't show just that they knew this ritual phrase about there was a personal benefit played by the tippee to the tipper.
It seems basic to the layman here, Professor, but insider trading, you kind of know it when you see it, but it's never been defined. And I guess, as you say, that's part of the problem, right? Because it's subject to interpretation?
It is a problem. This is judge-made law, and every circuit has different judges, so we can get conflicting ideas about the definition of insider trading in different circuits. So California and New York right now seem to disagree about what constitutes insider trading. And whatever judges say, they bind lower court judges, whereas Congress, if they would take this problem up, could come up with a fairly clear, maybe not perfect, but at least satisfactory standard.
In fact, a good friend to the show, Congressman Himes from Connecticut, who used to, by the way, work on Wall Street, along with some Republican co-sponsors, he a Democrat, they worked with you on crafting it, and I'm not trying to take away from your good works, but it's not that complicated to change the policy so that it's clear. And when folks are, I mean, the idea is that if we're investors, we should all be playing on a level playing field. You shouldn't be penalized if you do good research, but you can't be getting inside information. We should be able to write legislation that makes that clear, right?
You're quite right, but do understand the problem. The SEC has long feared and resisted legislation because they know the moment Congress gets its hands on this, there will be requests for special exemptions by every lobby in Washington. And there are hundreds of them. The pharmaceutical companies will want an exemption. The M&A merger takeover people will want an exemption. All of these people have a special interest, and the history of Congress is they don't resist special interests that well. So we need some strong presidential leadership here if we're going to get a good bill through Congress.
Well, let's keep our fingers crossed, and I appreciate the efforts on that front. John Coffey, Professor, thank you so much. I appreciate it.
Thank you.
Coming up next, even Freddie Gray's family's attorney was satisfied with the decision to acquit one of the officers who arrested Gray. So, did the DA overcharge and overpromise when she said she would get justice for Gray? Then, if you haven't seen this video, it's really disturbing. Taser death caught on a cop's body cam, raising a ton of questions about policing, body cams, and a whole lot more.